Crimes against humanity require a little bit extra. As stated, there's never been a Crimes Against Humanity Convention, and while Article 7 of the Rome Statute is as good a starting point as any, it needs to remember that not every state has ratified the Rome Statute. What does that require? It requires that for there to be crimes against humanity, the following crimes set out in Article 7.1, such as murder, extermination, enslavement, have been committed as part of a widespread or systematic attack directed against any civilian population with knowledge of the attack. It's that last element, the knowledge of the attack, that may not be customary international law, may not be required. But please note that for crimes against humanity, you don't need an armed conflict. Unlike war crimes, which must take place in either an international armed conflict or a non-international armed conflict, crimes against humanity can occur at a lesser stage of violence. That being said, it still must be widespread or systematic. Okay. Again, not defined. Two remaining elements that I wish to deal with in Article 1FA before moving on to the rest of Article 1F. The first of those is participation. If you mention participation to an international criminal lawyer, it can actually send them screaming into a corner. It is such a complicated topic, and there is no way in this presentation that I've got time to go into all the detail. This is why, if you're dealing with exclusion and 1FA is the basis for the exclusion, you really do need a specialist in international criminal law to assist. To that end, participation. Article 1FA requires that the person applying for refugee status who is being considered for exclusion has committed a war crime, a crime against humanity, a crime against peace. What does committed require? Now, the law of armed conflict, by definition, takes place against a background of disruption, mayhem, the usual investigative capacity of the police force is extremely limited. How are you going to get the evidence? Therefore, it's drawn up for itself a whole range of means by which to find people responsible for their activities based on participation. But it's a participation that is broader in many ways than would occur in domestic criminal law. For instance, command responsibility. This isn't the responsibility of a commander for actually giving orders. That's direct responsibility. This is the responsibility of a commander who does nothing when he or she becomes aware of violations of the laws of armed conflict by those under their command, or who ignores evidence that violations are taking place and thereby allows them to happen. Okay. It has become apparent that this command responsibility with respect to war crimes applies not just to military commanders but also civilian commanders of the military too. Other aspects of participation that can give rise to problems when looking at exclusion that are developed in the International Criminal Tribunal for the former Yugoslavia and the International Criminal Court are joint criminal enterprise. The ICTY had 3 varieties of joint criminal enterprise. The Rome Statute of the International Criminal Court has only adopted 2 of those. Alongside joint criminal enterprise, you have aiding and abetting, where the ICTY has come up with a range of ideas as to what is required if someone is to be found responsible for aiding and abetting crimes as set out in the ICTY. How far they'll be adopted by the ICC, how far they've been adopted by the Special Court for Sierra Leone, for instance, in the Charles Taylor case. This is all unclear at present. Complicity. Complicity is part of genocide. Is it part of other international crimes. Again, not quite clear. The US courts, when dealing with exclusion, have excluded on the basis of material support. Material support is where, in certain cases, according to US decisions, someone has, such as a doctor, provided assistance to, quotes, a terrorist group, unquote. Well, the doctor might have been doing that through fear, or because of the Hippocratic Oath that says they have to treat people. What about farmers who are required to grow narcotics by rebel movements or terrorist groups in order not to be killed? Are they providing material support? Are they participating? Have they committed one of the crimes? Have they supported those crimes? International refugee law has seen the concept of participation, whether it be in 1FA, 1FB, 1FC, develop considerably over the past 15 to 20 years. In the UK case of Gurung, mere membership of an organisation that used particularly violent means might in certain circumstances have led to you being excluded. That decision was reversed with it on that particular aspect within the case of JS Sri Lanka. The Canadians have decided the case of Ezekola. Again, these later cases, JS Ezekola, require much more direct involvement in the crime than mere membership of an organisation. Mere membership of an organisation, even if that organisation does carry out crimes against humanity or war crimes, should never be enough in and of itself to lead to one's exclusion. 1FA and 1FB for that matter require that if you're going to exclude, the person has committed one of those crimes, not just being a member of an organisation where somebody else committed them. The final topic I wish to look at in relation to participation for the purposes of 1FA relates to children. Children are directly affected by armed conflict, and it's for certain the case that some have participated in what would be, if committed by an adult, war crimes, crimes against humanity. How does that play out, though, with respect to exclusion, when one has a child applicant seeking refugee status? There has to be serious reasons for considering that this person, the child, has committed a war crime, crime against humanity. Now, national laws relating to the age of criminal responsibility vary, but in this particular context, I think that the general approach of the international tribunals, whether that be ICTY or ICC, but especially the ICC, their approach towards children should be followed, and that is that no one under the age of 18 can be found responsible for what they did, and to that end I would suggest that in relation to 1FA, no child should be excluded. Thank you.